there are contractual clauses that can help, whether it's shifting the responsibility to other parties in the supply chain through reps and warranties, asking them to make sure that they are actually doing things to mitigate the upstream risk, strong termination provisions, but most crucially, making sure that you've got specific solutions in your contracts to deal with things if goods are detained, requiring cooperation, including through parties upstream, requiring documents and information to be provided and maintained, making sure that there is a contractual obligation to be timely, and ensure that there is a response in a reasonable time frame, because the CBSA is putting 30-day timelines on information requests, and contemplating who's going to pay for it. If there's an allegation upstream that a supplier has been involved in problematic labor conduct and goods are detained at the border, whose responsibility is it to pay while this is all being worked out, and the legal costs of fighting that out?
The hearing resulted in what is now the seminal decision on forced assignments and provided a clear framework that the court can look at in deciding similar cases. Let me give you a little bit of background. In a CCAA, the Companies Creditors Arrangement Act, the Insolvency Act, and in fact in all insolvency proceedings, the court has the discretion to force the assignment of a contract notwithstanding the opposition of the counterparty to the contract, including leases. Notwithstanding provisions in leases that say assignments require landlord consent. This can be overruled. The court does not take that into consideration in deciding whether to force the assignment of the contract.
With respect to the sale of business context specifically, I think her decisions indicate that it is going to be very difficult as a practical matter, assuming a duty of good faith exists, to actually show that it's breached by a purchaser who declines to ultimately consummate the transaction with the vendor. Usually these LOIs are going to grant the purchaser a lot of discretion over the process, like the one here. And so provided that the purchaser has made reasonable efforts, I think, during the negotiating process, and particularly if they can point to a legitimate business reason for not closing, I think it is going to be very difficult to show a breach of a duty of good faith in this setting.